everybody. I want to talk about the meaning of the concept of persecution according to the Geneva Refugee Convention and its interpretation in the light of human dignity. Persecution is one of the key concepts of the Geneva Refugee Convention, but it is not defined in that convention. Since 2004, the refugee law is a matter of the European Union law, and the European legislator has issued a directive on standards for the qualification of aliens as beneficiaries of international protection, the so-called Qualification Directive, or in short QD. Article 9 of this directive gives a definition or an explanation of the term persecution. Article 9 consists of 265 words, and one should think that such a large explanation or such a large definition should cover all thinkable aspects of the meaning of persecution, so that we cannot have any doubt about the application of that concept. Unfortunately, a closer look shows that the opposite is true. The definition or explanation of the term persecution in Article 9 QD is very vague and very unclear. Article 9 provokes more questions than it really answers. I cannot demonstrate this for the entire provision, but I want to focus only on the first paragraph of the first section of Article 9. According to this provision, an act can be regarded as an act of persecution if it constitutes a severe violation of basic human rights. This sounds a little bit surprising, because human rights should be in general basic rights, fundamental rights. But the Qualification Directive distinguishes obviously between basic human rights and non-basic human rights. But what is the criterion for the distinction? Article 9 of the QD mentions in this context the rights from which derogation cannot be made under Article 15, paragraph 2 of the European Convention of Human Rights. Article 15, paragraph 2, the European Convention of Human Rights, lists 4 rights which may not be derogated even in the case of war or public emergency. So we can call these rights emergency resistant rights. And these are the right to life, Article 2, the ban of torture and inhuman and degrading treatment and punishment, Article 3, the ban of slavery and servitude, Article 4, paragraph 1, and the principle no punishment without law, Article 7 of the Convention. So it seems at the first glance that these rights are what is meant by basic human rights. But this is not true, because a closer look shows that Article 9 of the Qualification Directive says that the emergency resistant rights are in particular the rights that should be considered as basic human rights. So the emergency resistant rights of the European Convention of Human Rights are only examples for basic human rights, but this is not the definition of the term basic human rights. So we need a definition, and we need a complete criterion for the distinction between basic and non-basic human rights. The QD does not deliver such a definition, and so the question is, what should we do? My proposal is that the idea and the principle of human dignity can deliver an appropriate and sufficient criterion for the distinction between basic and non-basic human rights. However, first we have to clarify what should we understand as human dignity. In this context, I will recommend this book, the Cambridge Handbook of Human Dignity, edited by Markus de Wel, Jens Bravik, Roger Brownsworth and Dietmar Mead, published in 2014. If you have read this book from the first to the last page, you will know a lot about the different understandings of human dignity. The most of these ideas or approaches of human dignity are not sufficient for the purpose of being a criterion for the distinction between basic and non-basic human rights. And this is the case simply because there are the most theories of human dignity suffers from four important lacks. The first lack is the lack of language historical connexity. The second is a lack of metaphysical parsimony. The third is a lack of empirical significance. And the fourth is a lack of distinctive character, the lack of distinctiveness. Let me say some words to these four lacks. The lack of language historical connexity. The concept or the expression human dignity relates to a traditional philosophical term, and it makes no sense to use this expression in order to express an idea that is not connected with the traditional meaning of human dignity, with this traditional philosophical meaning of human dignity. Some or many theories of human dignity suffers from a lack of metaphysical parsimony. In contrary, they are based on a strong metaphysical belief, and therefore they are not appropriate and sufficient as criterion for the distinction between basic and non-basic human rights, or for the interpretation of human rights in general, because human rights are rights that are based on ideas that are universally meaningful, and it makes no sense to interpret such an universal idea on the background of regional, particular religious or traditional understandings. So we have to search for an understanding of human dignity that is more or less free from metaphysical pre-understandings. Many theories of human dignity suffers furthermore from a lack of empirical significance. This theories consists of very abstract ideas without any connection to empirical experience, so that we cannot decide whether a real empirical situation, a real situation in life, is in accordance with the concept of, or with the idea of human dignity or not. Other ideas of human dignity or other interpretations of human dignity suffers from a lack of distinctiveness. They confuse the meaning of human dignity with the meaning of other concepts or other terms. For example, with the idea of liberty, or the idea of equality, or the idea of solidarity, and others more. The term human dignity is only an interesting term if human dignity is something different from liberty or equality or whatsoever. If we avoid these four lacks, we will find that there is only one rational possibility to understand the concept of human dignity. And according to this understanding, human dignity refers to personhood. What is personhood? Personhood is a property of human individuals. And according to this property, individuals are able to lead their own life on the basis of own considerations and reflections, or in other words, on the basis of their own free will. And since they can lead their life on the basis of their own free will, we can consider them as someone and not only as something. I concede that this explanation of personhood is a little bit vague, but it is maybe easier to understand if we try to explain it from the opposite. So what is the opposite of a free will? The opposite of a free will is a will that is based on manipulation. Manipulation means that someone leads his life not on the basis of own considerations and reflections, but on the considerations and reflections of another person, of who manipulate him. We can roughly distinguish between three forms of manipulation. According to the first form, manipulation occurs by means of physical and mental pain. For example, someone who is tortured is not able anymore to lead his life on the basis of own considerations and reflections. He has rather lost the consciousness of his own autonomy and authenticity. He will be willing to subject himself under the will of others. The second form of manipulation of the will-making process is the manipulation by means of intellectual damage. For example, by oppression of the free speech, by censorship, or the manipulation of information, and things like that. In all these situations, someone is manipulated to lead his life according to the ideas and the targets and aims of other persons. The third form of manipulation covers all methods of deprivation of privacy, because privacy, a room where you are not observed and controlled by others, is elementary, necessary in order to be free to develop an own free will. Otherwise, if you have always to play a role in front of the public, in the front of others, outside of a room of privacy, you are forced to play a role and to lead your life in accordance to the expectations of the audience, of the public, and not in accordance with what you really want to do and what you really have in mind. Here is not the place to explain the concept of human dignity in more detail. For those of you who are interested in a deeper study of this concept, I want to recommend the following book, Human Dignity as a Foundation of Law, edited by Winfried Brugger and Stefan Kirste and published at Franz Steiner Verlag in 2013. But now back to the question of the distinction between basic human rights and non-basic human rights. According to the human dignity principle or human dignity criterion, we can distinguish basic human rights and non-basic human rights. Basic human rights are the rights that protect the freedom of will, while the non-basic human rights protect some aspects of the freedom of action. Basic human rights are the rights which protect the integrity, the physical and mental integrity of the person, the intellectual integrity of a person, and a minimum scope of privacy for any person. All the other human rights are not basic. These are, for example, rights like the right to free movement, for example, or the right to labor, or the right to vacation, or all the other human rights. So in other words, basic human rights are those who protect a certain kind of living conditions under which it is possible to develop a free will on the basis of own considerations and reflections, free from manipulation in order to lead your own life. There is only one basic human right that is problematic in this context. This is the right to life. And this is simply the case because the victim of a violation of the right to life is not, or has not, to live under inhuman living conditions. it is not the victim of a manipulation, simply because the victim of a violation of the right to life does not exist anymore. And therefore, it is in no state. In order to show that the right to life is nevertheless a basic human right, it is necessary to deliver a more sophisticated argumentation. Here is not the time and to demonstrate this sophisticated argumentation, and therefore I will recommend an article that I have written about this question. It is published in the annual review of Law and Ethics, Jahrbuch für Recht und Ethik, 2012, under the headline, "Is there a human right to life?" Thank you very much for your attention.